I am live on YouTube. I hope everyone's doing wonderful, magnificent, and great, like I said. And you're listening to your boy Jonah Bay. Peace, peace, peace. Yeah, I'm in my man cave right now. I wanted to be outside in the elements on, under the gazebo, but it's raining, so I'm sitting in my man cave. I didn't feel like being in my office. Yeah, y'all see the pool table back there, right? But anyway, let me continue reading the tricks and traps of court. Hold on, let me put it in the chat. Make sure everyone's following. Tricks and traps of court. You really can be doing everything right in court, and they're gonna be gaslighting you to make you believe you ain't doing it or your paperwork didn't work. It worked, but they're never gonna let you know. That ain't how they get down. So let's look at tricks and traps of court. Now, someone hit me Monday inside the email, and they were saying that they called the 1-800 number 626-6667 number because they tried to order a copy of the procedures for Texas courts can be found at that letter. Now, what I did, O'Connor's Texas Rules of Civil Trials 2001, I Googled it and got the book. But you can also get that book. It's other books, not that same year. They got a whole bunch of books that's upgraded, but you can read the other books. So you can get at least one of these books to know what's going on in court about how they doing all these tricks and traps, right? So we're going to start off with how attorneys' unsworn statements become facts and evidence and how to prevent it. I have not forgotten it's Consultation Wednesday, and I will be opening up the call lines and taking calls. But I'm going to read a little bit tonight. All right. So it says, trial court has the discretion to omit and exclude evidence. The appellate court will reverse only the abuse of discretion standards, right? So they're only gonna give you an appeal and say you're right if it's abuse of the discretion standards. That's how they reverse it. That's why you have to preserve, say, you always say it's a writ of error and you put it on the record, right? Let me go on. If the trial court sustains the objection, it will not admit the evidence. The party who offered the evidence still has other options that it must exercise, or it waives the error. If the trial court overrules the objection, it will admit the evidence. The party whose objection was overruled still has options that it must exercise or it waives its error. Like, say, for instance, you saying you object and they say overruled, you're supposed to say, I take exception to the overrule. That preserves it on the record that, you wasn't having it and you wasn't waiving your right. All right. Then it goes on, an attorney unsworn statements are not evidence. U.S. Government versus Marks, 1997, they established that. However, on appeal, a lawyer unsworn statement can be considered evidence unless the other side object at the trial. Brandon versus Garcia, 1997. So every time he says something out of his mouth, you got to object when he's trying to talk about facts of the case. I object. He's not a competent witness. He wasn't there. He's not talking from a point of view of being there. And if he feels like he is a competent witness, let him swear in so I can cross-examine. Right? That's the way you want to handle that. So let me go on. Normally, an attorney's unsworn statement must be under oath to be considered as evidence. Banda Supra If a lawyer is presenting facts to the court, the other party should object and ask the lawyer to be sworn and subjected to the cross examination. And that comes from the case Banda Supra. When in doubt, a lawyer should always object to the fact statements of another lawyer. That means you need to object to all the facts and statements of the other lawyer every time. Doesn't matter if they try to cut you off. Once they stop, you say, well, you cut me off, but I still object to that lawyer saying anything. He's not a competent witness. He doesn't have firsthand knowledge. If the other party is unaware that the lawyer is testifying and does not object, the administration of the oath is waived, right? So, and that's Fullwider versus American Guard and Lab Inc.'s Co., 1991. All right, let me go on and read. Note that disciplinary rule of professional conduct 3.03 forbids a lawyer from making false statements of material fact to a tribunal. So it is presumed that when an attorney is stating facts without being under oath, not subject to cross-examination, the statements are facts unless objections is made. Anytime an attorney starts stating facts, it is most likely hearsay unless the attorney has firsthand knowledge of the facts. And even then, the attorney must be under oath and subject to cross-examination unless the other party fails to object. Almost every time an attorney opens his mouth, the opposing party should be objecting. Did you hear that? Every time y'all in court, anytime that opposing attorney says anything, I object, I object. Even when the fucking judge says shit, I object, judge. I take exception. You're practicing law from the bench. You are not being impartial, judge. I object. I need you to recuse yourself. Stop fucking talking. The trial is against me and that attorney. You're not supposed to be helping him or me. Y'all got to learn how to talk like that. Stop trying to talk like lawyers and shit. Talk your shit, king. Talk your shit, queen. Talk your shit, God. Let me go on. When trial counsel foresees the possibility that he or she will testify on behalf of a party about disputed fact issue, not attorney fees, the lawyer should resolve doubts in favor of preserving integrity of the evidence and decide continued participation of the trial of counsel. See, so you can say, yo, I'm not continuing. Y'all keep on doing this. I'm not continuing. I'm going to walk the fuck up out of here, man. Y'all are not being impartial. And the judge won't keep on talking. He keep on practicing law from the bench. I'm walking out. Peace. It's going to be on the record if you do that. You got to stop being scared. Y'all brothers ain't scared to fight niggas on the street with guns or anything else. But in court, y'all scared. Stop being scared. All right? Let me go on. Where was I? I'm going to just start here then. When a trial counsel foresees the possibility that he or she testifies on behalf of a party about a disputed fact issue, not attorney fees, the lawyer should resolve doubts in the favor of preserving the integrity of the evidence and decide against continued participation of the trial counsel. See Willard versus Norrell, 1989. A testifying lawyer may still engage in and out of court matters relating to the case, including preparing this and signing pleadings, planning strategy, and negotiating settlement. Anderson Prague Inc. versus Koch Oil Co., 1996. So when the lawyer starts testifying to hearsay facts, the pro se should be objecting and demanding he take the stand under oath, submit to cross-examination, and that he withdraw as a trial counsel. Yeah, you need to tell them, yo, since he's doing what's the name, he needs to withdraw as counsel since he's a witness. If he's not a witness, then shut the fuck up about facts. He knows nothing about the facts. Right? Then let me go on. A party should attempt to secure an explicit ruling, admitting or excluding evidence. That is a ruling on the record, either in open court or in writing, that specifically states that the court's ruling, i.e., that the objection is overruled or sustained. And if the court does not make explicit ruling but omits evidence over a specific objection, the court implicitly overruled the objection and error is preserved. Right? So you gotta do it that way. Say, and on for the record, I want you to say that it's overruled or sustained. If you don't, I take exception to it. So that was Wolf versus Wolf, 1986 case. Now, with that being said, I'm gonna play my commercial. Then after the commercial, I'm gonna come back and open up the lines for questions.
Are you dealing with the legal situation? Are you being stopped and questioned by police for no reason? Got you feeling like the deck is stacked against you? You can get everything you need to protect yourself, your rights, and your property at JonahBay.com. You can learn how to remove that so-called judge from your case with the writ of penitence and assises webinar and template. Get that so-called judge out of here. You can learn how to save your money so you can make money with the Discharge webinar DVD right here at JonahBay.com. While you're there, you definitely need to pick up the injunction webinar and template. Don't believe me? Check this out.
Peace to the gods. You're now listening to the sounds of Hindsight Radio.
I want to share a story regarding the injunction. I did the injunction, and I was stopped by the police. I didn't realize it. So he said ticket, and so he went to his car and ran my plate, and I literally mean he almost ran back to my car with my and said, "Have a nice day," and sent me on my way.
What happened to the ticket, though? Where's my damn
no ticket. He sent me on. He told me to have a nice day and sent me on my way. So the injunction does work.
Don't visit JonahBay.com.
At JonahBay.com, you can choose from a wide selection of webinars, seminars, templates, certified documents to get your revenue. He could teach you how to go ahead and get out of debt. And not only get out of debt, but to be self-sufficient where you don't need to go ahead and utilize the system. You are the system.
JonahBay.com.
All right. So let me get to these calls and answer these questions. I'm going to 585-328. Peace to the God. Peace.
Peace to the God.
Peace to the gods. What's up?
I'm doing wonderful, magnificent, and great.
Ashe, you've been hiding, ain't you?
And I'm so happy that Laura's sons of wealth, good health, come to you, I, and the listeners, ASAP and easily.
Ashe. You know, this year I'm gonna make sure I do the money ritual again because they doing funny shit with this money. So we gotta be prepared and get these wants from the universes out there ASAP. So what's up?
Yeah, the universe working in your favor. If you're doing what's right and exact, the universe working with you. I'm sure a lot of people can feel that every day.
Right. So what's going on with you?
Well, I like the read that you're doing. I haven't had a chance to go over it, but I'm reading it over with you.
That's why I did it, to make sure people hear it and learn from it. Whether they read it or not, they're gonna read it with me. Screw that.
Yeah. Yeah, and I like the part where it's kind of like putting in, fine line that what the judges are supposed to do, what they can't do, giving you some case law to be able to work with, to enforce it, and you go in court.
Exactly.
So I have two questions tonight, and my first question is pertaining to, I guess, something like this, but with summary judgment. So in my particular case, I've already moved to compel the attorney for a notice to produce, and I have still yet to hear back anything from them.
Okay, then you're gonna ask for a summary judgment and make sure you put in the date of hearing, a motion for hearing.
Oh, okay. Now, when I do that, do I have to go by that one rule where you, I guess, look on the dates and just pick one from there?
Man, I'll be just picking a date for 2 weeks. Either they gonna agree or disagree. You feel me?
Okay. Yeah, I just didn't want to put the summary judgment in too soon because I was just doing a little studying over the weekend.
Right.
Seeing that, you want to have your facts all lined out and stuff like that. See what the other party claiming that they got against you.
Right.
Which I know can be crushed, So I just wanted to make sure I was putting in summary judgment at the right time for that.
I know summary judgment is normally around 30 days for most places, but some of them got different rules.
Yeah. Okay. So my second question is dealing with the trust. And look, Mom, there's Fred. And then
what up, Fred?
I got a gopher in my backyard. Come visit me every day.
Fred, like he hungry. What y'all got to eat?
Yeah, he like grits, Mama, I say. So anyways, I'm talking about the trust, my second question, and I believe that the county and the city is trying to pierce the trust. So the reason that I'm saying that is because I put the tax injunction in, and I put the commissioner here of my county and also of my city, because here where I live, I got a city municipality in the county.
Right.
So they sent me a bill in the mail, but previously, before me putting this enforcement letter, which is an injunction in, I had, a couple years ago conveyed the property over to the trust and all the rest of those things. So my question tonight is there something that I could have been missing when putting in my tax injunction and probably putting in some paperwork, to put the house in trust to enforce, not having to do that property tax?
When you put it in the trust, did you do what's called the homestead exemption?
So that's a question that I have for you tonight. I think here in New York State, we do have the homestead exemption.
And you got to do it constitutionally. Now, also, what you're supposed to do is go to the land bank and look up the original land grant for
So I have that.
Your parcel. Now, add the trust as the owner onto that land grant. And then once you do that, you take it down to the tax assessor's office at your county and show them the land grant, and you write a letter saying that, this is in a trust and the trust is on the original land grant. They should take you off the tax roll.
Okay. So that process that you're telling me right there is kind of like involving this Homestead Act that you're mentioning to me?
Well, it's actually separate, but I put in the homestead and I didn't have to do all that.
Okay. All right. So I guess if I have some more questions about it, because I'm not a little privy to Homestead Act. Like I heard about it before, but I guess
You're going to read your Constitution and read it in your Constitution.
Oh, about the property.
About the Homestead Act. Yep. That's how you're going to learn about it. All right.
Well, thank you, Big Daddy Moses. And
thank you.
I appreciate you, and I'm grateful and thankful for you for giving us this information at this particular time on the planet.
Ashe. Peace.
Ashe. Peace.
All right, I'm going to 763-501. Peace to the God.
Peace.
What up, God?
Can you hear me?
Yeah, I can hear you.
I had a question about. I haven't had to deal with it myself yet, but at some point down the line, might come up with something. How do I deal with them and preferably prevent, the mental evaluation order? If I'm taking something in court and they're trying to,
Now,
sabotage.
how you prevent the mental evaluation? You can go and get one yourself from anyone that says that you're sane and hand it in as evidence. They do that a lot to pro se litigants to try to stop y'all from defending yourself so that they can put a guardian ad litem on you, and the guardian ad litem will give you a court appointed lawyer. So yeah, it's called the Rule 11. They tried that like 20, 30 years on me, man, ago.
Is the Rule 11 the name in state and federal, or what?
I don't know. In state here, it was called the Rule 11.
Okay.
But I don't know it for every state or federal. You feel me?
So you think, like, basically when you're saying that when they order that, then I go get it. I don't get it preemptively,
You're going to get it
that.
preemptively to make sure they can't try that shit on you.
So don't wait till they order one. Do
Hell
it preemptively.
No. Hell no. If you already had one, you could have just handed it in and said, "It ain't no need. I'm sane."
So there's a certain amount of time that would make.
You're asking too many questions. Just
like
do
that.
it, my nigga.
All right.
Don't make it that complicated. You feel me?
All right. As far as the life insurance, you got a trust that owns the life insurance and is the beneficiary, or what?
I got several. I got it set up several ways. So your answer is yes, but that ain't the only way. You got individual, and then you got the trust doing it. And if you have a corporation that you own, you can have the corporation do a policy. You can get as many policies as you want. It's up to you to choose which one you want.
So the one I got, it does not have, trust involved. But they said I could transfer it into a trust if I wanted.
Then listen to them.
Do that.
Yeah, listen to them. Do it. You you got the trust. Do it.
All right. Now, should I make the trust the beneficiary, or should I have a beneficiary?
You can make the trust the beneficiary or not. It depends. If you want the trust to distribute all the money, yes, you would want the trust as the beneficiary, and then the trust indenture would say who it goes to. You feel me?
Yeah. You think there's an advantage to doing it like that?
The advantage is, let's say your kids is going to get money. The trust can determine them. They have to do certain things before they can get the money. That's how most of the rich do it.
So it'd be like the trustee, who would kind of like make sure that
I ain't gonna front. You're gonna have to pick up. It sounds like you don't know pretty much nothing about the trust. You're gonna have to pick up the trust webinar and go over it.
I got it.
Then you need to study it, because the questions you asking makes it seem like you know nothing about trust.
Does the executor stay involved, or is that only at the beginning?
What you mean executor? See, I didn't say executor in my trust webinar, dog.
Oh. All right. I got to get that out the vocabulary then.
You know what I mean?
Appreciate it. That's all. Yeah.
All right. Peace, God.
Peace.
All right, I'm going to 757 755. Peace to the God.
Peace to the God.
What up, God?
What up, God? I'm so happy and thankful that Allah comes when it comes to me quickly and easy. So I did my discharge, right? And all of them pretty much said the same thing. I just learned though that a couple of them was credit unions that I couldn't do.
Right.
I read a couple of cases where credit unions did that. You can't.
I told you that. I've told you that several times in the seminar. I told you on the air too. If you were listening, you can't do what's the names because they give you loans for real.
Right. They actually give you money.
Yeah.
But the rest of them I did. The only response I got back was it wasn't a valid rally number. So what I did, I sent it back with the red ink, letting them know they was breaking the law for 12 USC code 95. So I sent that back, and they sent the check back. All of them sent it back to me. So now I'm just stuck. I don't know what else to do now. And I finished the ministry. I did it 3 times.
You sent it to them 3 times, and they sent the check back. See, because check it. What they're doing is you got accord and satisfaction on the actual instrument. So they're thinking they have a choice because of accord and satisfaction. You need to write them and explain they are not protected because of accord and satisfaction. They have to discharge because of HR 192 and 12 USC, right? But then also you need to say that if not, you have intent on suing the CEO.
I just got taken to court then.
I did not say that. I just told you what to do.
Okay.
Why did you take it and put some other meaning to it? That ain't what I said.
Hold on a minute. So write them the warning and say that they don't.
It's called the intent to sue. You're gonna write them an intent to sue, and you're gonna break down what they can and can't do. You know what I mean? Because they thinking accord and satisfaction. They probably even never read your goddamn injunction.
Right.
It sounds like they're just looking at the instrument. You understand?
Right. A couple of them sent me the original contract back.
That has nothing to do with you are not obligated to pay no bills. The U.S. is. Now, here's the thing. You could want to go to court and all that. I didn't explain to y'all many a times with the Walker case, right? The Walker case is when in Chicago they brought the Fed into court, and the judge ruled that the Fed didn't lend money, and that and I've even played it on the air, the audio of that case, and that they making money off of your they actually created the loan and gave you the loan off the promissory note that you gave them, and they put the promissory note on their books as a positive account.
I thought that was the Jerome Daly case.
Is it Jerome Daly? I thought it was Todd Walker, but Jerome Daly, yes. All right, so, right? But what you got to know about it is look up and see who the judge was. They killed that man a few months later. So what am I saying? You are 100% right, but what judge is going to rule in your favor and get killed? No one's going to do that. So all you got to let them know you know what the fuck you talking about, and you make them believe you can win, and then they'll do it. But as I keep on telling people, a thief is not deterred by a lock, right? A lock only keeps honest people out. If the person is a thief, ain't nothing you could do to stop them from stealing.
Okay. So I supposed to send the check back with the letter again?
Yeah.
Okay, cool. All right.
Because they sent you the original check back, right?
Yeah, they sent the original.
Yeah, send it back.
Okay, cool.
All right then. Peace, God.
Right, peace, God.
I'm going to call her 636-249. Peace to the God. Peace.
Peace to the God.
What up, God?
What up, God? What up? I really didn't have much, but this is the last caller. I just wanted to say, the bank, well, one bank with me, it's a credit card, or it's a credit card, parent credit card. They just froze my stuff. You know what I'm saying? We kept going back and forth, and you know, I threatened the shit out of them. Excuse me, French.
And you know what y'all could do?
Another bank closed my account. They closed my account. This particular place, I didn't got them to the point where I felt like they was extremely nervous. I spoke to 3 different people, all the way at the top, and to this very moment, it's been about 1 or 2 months now. They got to the point where it's like, sir, we're just looking into it. We're just looking into it. At first, it was like, no, you can't do this, you can't do that. We're not going to take any more phone calls from you. To look, we're looking into it. Just give us some time. And
so they actually found out all the laws you recited is real.
Yeah, but it's just still right now. I mean, like I said, they definitely seem wary because they took me. I thought I was at the top. Speaking to the president, and then, speaking to the president because the chain of command, CEO, CFO, to some people who I'm not even sure who they actually were, but I know every word I said they were typing.
Now, one thing I want y'all to tell them, in your instruction, you can tell them just do a 1099-C on it. If you already got
when I did that, when I did that, Jonah, because you told me about that. When I did that, when I gave them an option ultimatum, that's when they went back into okay, let's continue communicating, and we're looking into it. That's what got me to the next part. Yeah, because at first it was just okay, then it was oh hell no. No, at first it was hell no, then it was okay, then it's hell no again. And then when I hit him with that right there, getting the ultimatum, it's oh man, this guy really know what he's talking about.
Exactly.
I'm gonna tell you something else. What I wanted to ask before I say this, see that's consumer laws right there as well. Can we include the attorney general?
You can.
Is that, not a good idea?
You can, but he ain't really above.
I made a complaint. What?
He ain't really above them, but he can put pressure on them.
Yeah, I definitely made my consumer complaint. Because
listen, I could care less if I got a $10,000-$20,000 credit card, right? And they close it down, you know what I mean? Then I don't have to pay that. I'll just open up a new creded card. You see what I'm saying?
Yeah.
Long as I don't have to pay that $10,000-$20,000, right? But and then if they do a 1099-C, I don't care. I did my tax injunction. Last week, I'm supposed to show Monday. I'm gonna come in and read that thing from the IRS where they're trying to protect all their people because they know taxes is fraud and unconstitutional. It's slavery because of that tax injunction. But yeah, please do 1099-Cs, and I'm not going to be paying taxes on that, so I don't care.
Right, and that's the next thing. I realized, with it being taught, I'm like, you really need to acquire these things first before you do that. It'd be a good idea too.
Yeah, I showed people how to discharge after I showed them how to do the treaty injunction and the tax injunction. And I did that for a reason. Now, if you go skipping steps, I don't know how it's going to turn out for you.
Well, my last, something else came.
But if, I can tell you, if you don't have the tax injunction in and you tell them to do a 1099-C and they do it, the IRS is going to send you a bill for the exact amount that was just discharged.
Even if you didn't get it yet?
Even if you didn't put in that tax injunction, that's what's going to happen. They count 1099-Cs as income.
Right, as income, exactly.
Yeah.
They supposed to use the C or the A, and you write that.
So if you didn't tell them, yo, I'm not required to pay none of your taxes, that's slavery and against the Constitution by doing your tax injunction, yeah, they're going to send you that bill.
Okay. All right, well, last thing, any updates on for as the discharge in the houses and things like that right now?
I don't have they asked for more time. They asked for another 60 days. So I'm giving it to them. I'm just writing under duress. And then I'm about to write next communication. I'm going to tell them to do a 1099-C.
Okay, because that's exactly what I did with the credit card. I just I'm paying them under duress, and just giving them more time, They didn't give me a date like you, but that's what they said though.
Right.
We're working on it.
Right.
But okay, well, peace to the guys. I appreciate it. I'll keep
peace to the God. What I want y'all to know is this money system about to collapse, right? So they might try to keep it going on. They trying to do a grab for as much money as they can. Because I tell you what, if you did the discharge and they changed the money, you definitely discharged 100% because they broke the contract 100%. So keep that in mind, y'all. It's like a claim that they're going to have to, it's going to become due. I'm going to 111111, which is a computer. Peace to the God. Peace.
Hey, Jonah, what's up?
What's up?
Yeah, so I had Kiana on the line.
Oh, she there now?
Yeah.
Tell her get it in. Get it in.
Hey.
Peace.
So I'm currently fighting a speeding ticket in Kentucky, along with not wearing a seatbelt. I'll be going in for my next court date on Monday, actually, for a status hearing, supposedly. This will be like my fifth court date with them. The judge does not want to dismiss the case. Do you have the audio? Do you want to play the audio? Do you have any questions for me in particular that you want to ask?
I wanted to play the audio, but I had to get, permission to do that. But see, then I had thought about it.
Jonah.
Huh?
Oh, okay. I told you to go ahead and do it earlier.
Yeah,
you ain't been looking at your phone.
Remember, I thought about it and I said, if I play it, they're going to interrupt my feed. That's why I put it on,
snippet.
I'm going to have to get someone that can put it in a snippet. I'm going to talk to Shaka because I really want people to hear you as a newbie in court. Through all that studying, you did almost everything right. If it was a test, I would give you a 99. Right? Seriously.
Yeah.
And only reason why I'm giving 99 because you gotta give some room for improvement, 1% at least.
Mm-hmm.
But and I want people to hear because how long have you been into this information and under Jessica and me?
It's been about a year and a half now.
And to be that good in court, that is very impressive.
But she didn't start the court stuff until she worked on the trust forever. So I would say as far as the court part of it, she just got court stuff since she's been in court, literally.
Really?
It just started in March. Yeah, in March.
So you got all of that down packed since March. It's only May. That is beyond impressive.
Yeah.
I mean, I listened to your audio.
He asked me, like, what do you want me to?
And it reminded me of when I was in court.
Yeah. Oh, wow.
It reminded me of my audio in court, man. It really did. I was like, wow. And you felt, it seemed like you felt right at home. You were super comfortable. You talked the way you regularly talk. It was very impressive. You wasn't scared at all.
I followed the fucking script.
And that's what I want. Yeah. See, that's what I wanted people to know, because when I'm listening to what you were saying, I'm like, yo, that's her paperwork. She's following the script. Like I said, yo, don't go outside your paperwork. You got them people so scared and frustrated, it ain't even funny.
Yeah, because she didn't know what to say to me half the time. She just
I seen that. Okay. She was stuttering as a judge. And the way you told the lawyer to basically shut up, you ain't got no firsthand knowledge, you can't speak, that's hearsay. I was like, bingo. Bingo.
Since day one, Jonah. Since day one, we put Trisley in. I said, go for it. Don't let him say shit.
Trinsky versus Pagliaro.
Don't let him say shit. I said, don't let him say nothing. And he was sitting there like a deer with a headlight.
Exactly. And you know, I just read it from the Tricks and Traps of Court. Don't let them say nothing. They have even if they're saying your name and you're this age and that age, hearsay. He don't know that for sure.
Yeah. Exactly. Then he tried to sneak and say, "Does she have a license?" I heard him try to whisper to the judge on another court hearing. Yeah, he was trying to get testimony at one of the court cases. I told him, like, okay, well,
90 seconds.
Back on the case, why don't you go under oath and submit yourself to be cross-examined?
Thank you.
He ain't say nothing.
Right.
Nothing, Jonah.
He ain't say nothing after that. And that's exactly what I just read to him from the Tricks and Traps of Court. But now you telling them firsthand knowledge of what you did. Shut that damn lawyer down.
Shut him down. She had to pick his ass up every time. She had to keep trying
60 seconds.
It was so funny. Oh my God.
That's dope.
All of that stuff worked though.
Yo, I'm sorry I got to y'all so late. If it's possible, can y'all come back on Monday so we could discuss more and I can try to get that snippet done so we can play it?
Yeah, try to get the snippet done. We'll come back Monday.
All right then. Peace to the gods. Thanks you for chiming in tonight.
Oh, she got a court date Monday, so it'll be more.
Exactly. All right, peace.
She do it early in the morning.
Good. All right. Thank you for tuning in. That's our show for today. I'll see y'all again Monday. Peace to the gods.
Thank you for using Blog Talk Radio. Goodbye. 10 seconds.
See, that's what I'm talking about, y'all. I'm the real deal. Y'all will hear over, since I've been on the radio, people that have learned from me come and do testimonies, real live testimonies of what they're doing, what they've learned from me and done in court. And it works because it's their rules, it's their laws, and the Constitution. Straight like Noble Drew Ali said, enforce the Constitution. You see what I'm saying? So y'all don't have to believe me. Believe the people that's just like you. No other teachers out there have people coming in giving testimonies on the regular. And I've been doing it for over 10 years on the radio and been having testimonies from day one all the way up to now. And it's never going to change because it's real. All right. But thank you for tuning in. That's our show for today. I'll be back Monday. Peace to the gods, YouTube.